He was born in the spring of 1987 in Selma, Alabama, the son of a high school math teacher and a janitor at the local courthouse. His name was Isaac Freeman. His earliest memories were of dusty sidewalks, grand oaks draped in Spanish moss, and the distant rumble of cars that crossed the Edmund Pettus Bridge each morning. His mother, Evelyn, was a devout woman of quiet strength who taught math at Booker T. Washington High School, insisting that logic and reason were the tools by which one navigated a world often ruled by arbitrary prejudice. His father, James, worked the night shift, cleaning the very courthouse where young Isaac would later sit vigil in solidarity with protesters. At home, the television always hummed with the news of legal battles, school desegregation cases, sit-in demonstrations, busing controversies. Even at 6 years old, Isaac intuited that the world beyond his bedroom window was governed not only by laws but by power, and that sometimes the two diverged cruelly. Growing up in Selma during the early 1990s meant living with the legacy of the civil rights movement. Souvenir shops selling postcards of marchers cuffed at the bridge, plaques commemorating Bloody Sunday, and museums recounting the sacrifices made for freedom of assembly. Isaac noticed the subtle ways people retrenched racism even after it was outlawed. The older grocery store clerk, who slipped him extra change because boys like him didn't take money seriously. The substitute teacher who corrected his grammar more pointedly than that of white classmates. The way extracurricular opportunities seemed to vanish for black students at the first sign of academic promise. His parents spoke in measured tones at the dinner table, passing along lessons of dignity. Be aware, his mother would say, but do not stoop to their name-calling. Let your work speak for you. His father added, there are times when silence is disrespect to yourself and your ancestors. There's also a time and place for confrontation. Those early admonitions shaped Isaac into a thoughtful, inquisitive boy who read voraciously, first comic books, then biographies of Thurgood Marshall and Constance Baker Motley, and finally, United, State Supreme Court opinions. Sitting on his front steps, he would recite passages from Brown versus Board of Education under his breath, trying to understand the dense legalese. In high school, Isaac excelled academically, especially in debate club. He was drawn to mock trials in which he argued constitutional law. He saw in those exercises not mere academic contests, but the tools of real-world change. He and his debate partner, Athena McClendon, who was already a gifted orator, traveled to tournaments across the Southeast. Their topics often centered on hate speech, affirmative action, or sentencing disparities. Isaac would pore over appellate opinions to support his position. Athena would weave duty and morality into her rebuttals. On weekends, they roller skated down Broad Street, talking about Supreme Court justices and the possibility of using law to transform society. Outside of school, Isaac volunteered at the Selma Youth Legal Aid Office, where he saw firsthand how charged criminal justice issues played out for black youth. He watched as cousins and neighbors were stopped for walking while black and readied themselves to talk their way out of handcuffs. He listened to defense attorneys counsel families on how to plead if the badge turned unkind. From age 15 onward, those experiences fueled Isaac's determination to become a lawyer, believing that only from within the legal system could one dismantle its worst abuses. When he graduated in 2005 as valedictorian, he received a small scholarship to attend Spelman College in Atlanta. His parents saved every penny they could to send him and loaned him a barely functional sedan so he could drive to school each fall. At Spelman, he majored in political science with a minor in philosophy. He lived in a dorm named after Septima Clark, the educator-activist who had championed citizenship schools. Her spirit seemed to whisper through the hallways. In his first-year seminar on justice and the Constitution, he devoured articles by Derek Bell and Kimberlé Crenshaw, discovering the concept of critical race theory. One afternoon during office hours, his professor, Dr. Leland Moorer, told him, "You have the makings of a scholar who can speak truth to power, but don't lose your passion in the academy. Keep your roots in community." That advice resonated deeply. Over weekends, Isaac traveled back to Selma to tutor students in the debate camp he helped found at his old high school. He continued volunteering at the Youth Legal Aid Office there as well, mindful that he could not forget the tens of thousands of black Alabamians whose lives were still shaped by unfair policing and subpar schooling. In the summer after his junior year, he interned at the Southern Poverty Law Center, SPLC, in Montgomery. He worked on a project examining the patterns of stop and frisk in Mobile County, helping compile data that showed black residents were 60% more likely than white residents to be stopped. He also researched a proposed lawsuit challenging the redrawing of legislative districts that diluted black voting power. Under the mentorship of civil rights attorneys like Sam Spade and Angela Richards, Isaac honed his understanding of constitutional litigation, observing them file brief after brief, sometimes triumphantly, sometimes in defeat. He saw the slow grind of systemic change. He realized that legal victories could take years to materialize, but he also absorbed the determination that every filed lawsuit etched a record, every motion preserved a principle, and every ruling set a precedent for future cases. In his senior year, Isaac was elected president of Spelman's student government, where he led campaigns to increase funding for community health clinics in Atlanta's poorest neighborhoods. He also assisted with student protests against predatory payday lenders near campus. When those protests turned tense, some students chaining themselves to lampposts outside a check-cashing storefront, Isaac negotiated with police to allow a peaceful demonstration. His ability to bridge student demands with the concerns of law enforcement earned him praise from both sides, reinforcing his belief that law could serve as both a sword and a shield. He graduated summa cum laude in 2009 and was accepted at Yale Law School with a full scholarship. As he traveled north to New Haven, his family packed his childhood keepsakes into his Chevrolet and whispered heartfelt goodbyes. His grandmother Mabel wept and said, "Remember who you are and why you fight. Remember that your people marched so you could enter those halls." Sitting in the back seat, Isaac repeated her words like a mantra, steeling himself for the challenges ahead. Yale Law School proved to be both exhilarating and disorienting. In the fall of his first year, he enrolled in civil procedure, property, and constitutional law, each class broadening his understanding of jurisprudence, but also introducing him to peers from elite preparatory schools who seemed to have no sense of the social injustices he found so urgent. He felt an early pang of imposter syndrome when classmates casually discussed summer internships at corporate law firms he had never heard of. But he soon found his tribe in the student group called Legal Outreach, which paired law students with public defenders, civil rights attorneys, and nonprofit legal clinics. He volunteered at the New Haven Legal Assistance Association, representing tenants in housing court and drafting motions for clients facing eviction. It was in that cramped basement office, illuminated by fluorescent bulbs, that he saw the law at its most human. A judge admonishing a single mother who could not pay rent, a harried attorney arguing for a veteran's benefits, a clerk warning him that pro se litigants rarely succeeded. Within those walls, Isaac learned that advocacy was not just about brilliant arguments, but about mercy, humility, and connecting with clients on a human level. It was during his second year that he felt compelled to join a protest in New Haven after the police shooting of an unarmed black teenager. The vigil had begun at Yale's Bayneka Plaza, where students lit candles and prayed for justice. When a small group of protesters marched down Chapel Street chanting, "No justice, no peace," they were met by riot police in tactical gear. Isaac, wearing jeans and a Black Lives Matter t-shirt, raised a fist above his head as the protesters knelt in the middle of the street. The police swung batons and pepper-sprayed the crowd. Isaac felt a burning sting in his eyes and tried to help an elderly woman who fell to the pavement. In the chaos, an officer grabbed him by the collar, slammed him against a squad car, and handcuffed him. He spent the night in a cell with two other men, one arrested for being in the wrong place, another for trespassing. That night, he lay on the thin mattress, his shirt damp with sweat, listening to the howl of sirens outside. A fellow cellmate, a kind older man named Winston, who taught GED classes in New Haven, said quietly, "Sometimes you get locked up for fighting the right fight." Isaac repeated that in his mind, tears stinging his eyes as he thought of his grandmother's words, "There is a time and place for confrontation." The next morning, after being released on his own recognizance, he returned to campus to face disciplinary proceedings. Yale's administration suspended him for one semester, citing disruption of campus order. Some professors supported him, arguing that his actions embodied the ethic of legal advocacy. Others remained silent or questioned whether a law student should be arrested while studying how to be a lawyer. Amid that tumult, Isaac plunged into his coursework even deeper, devouring writings on civil disobedience by Thoreau and King, analyzing cases like Reed versus Reed and Yickwo versus Hopkins for how seemingly neutral laws produce discriminatory outcomes. The suspension prompted him to defer his studies for 6 months and return to Selma. At home, he reconnected with local civil rights elders, men and women who had marched in the 1965 voting rights movement. He spent days learning about the case of Harrell versus State of Alabama, in which state troopers were accused of using excessive force against peaceful protesters. He interviewed survivors who remembered the sting of tear gas and the crack of batons. He volunteered at the local NAACP chapter, drafting amicus briefs for cases challenging school disciplinary policies that disproportionately targeted black students. By the time he returned to Yale in fall 2012, he had a renewed sense of purpose. He would become a lawyer who could stand before the highest courts of the land and demand true equality under the law. Back at Yale, he kicked off his third year by securing a coveted clerkship with Judge Patricia Chen on the United States Court of Appeals for the Second Circuit. There, he researched and drafted opinions on cases about gay marriage bans, police immunity, and sovereign immunity for Indian tribes. His legal reasoning was praised for its clarity and compassion. One evening, Judge Chen leaned over and said, "Your passion for justice is rare. Never let that fade." He nodded, determined that his real test lay ahead, representing causes, not just writing opinions on appeals. After graduation in 2013, he returned to New Haven Legal Assistance as a staff attorney, representing indigent clients in civil cases. He accumulated dozens of pro bono victories, securing guardianships for disabled adults, reversing wrongful evictions, and ensuring access to special education services for children with disabilities. He also joined the Connecticut Civil Liberties Union as a cooperating attorney, representing protesters arrested for free speech violations and challenging discriminatory parole practices. But his ultimate ambition was to fight at the federal appellate or Supreme Court level. To position himself for that opportunity, he sought a fellowship at the NAACP Legal Defense and Educational Fund in New York, focusing on national coordination of litigation to challenge mass incarceration and voting rights restrictions. In 2015, he moved to Harlem to begin work at LDF. He immersed himself in cases challenging felon disenfranchisement laws in Florida, Louisiana, and Virginia, arguing that such laws were modern vestiges of Jim Crow designed to suppress black voters. He contributed to the landmark decision in Brown versus Motor Vehicle Division of the Department of Public Safety of Ohio, a case challenging voter ID laws that had been enacted under dubious pretenses. When the Supreme Court denied certiorari, he was disappointed, but he carried the lessons forward. Litigation was a marathon, not a sprint. He also joined the Justice for All campaign, a coalition of civil rights groups mobilizing to pass the Voting Rights Advancement Act and to challenge gerrymandering. He regularly traveled to state capitals, meeting with legislators, organizing town halls, and assisting local activists in drawing warnings about the legal arguments they would face. In 2016, after 2 years at LDF, he was accepted as a Skadden Fellow at a new position in Jackson, Mississippi, with the Center for Racial Justice focusing on police accountability. He relocated south, returning to the region of his birth, feeling the ghosts of Selma guiding him. In Jackson, he filed lawsuits on behalf of families whose loved ones had been killed by police, represented teenagers subjected to stop and frisk practices, and challenged the city's asset forfeiture policies that preyed on poor black residents. In one high-profile case, he represented the family of a young black man shot by a patrol officer who claimed self-defense. Under his leadership, the case secured a settlement that included a public apology, officer retraining, and a review of departmental protocols. He organized community forums to bring residents and police officers together to discuss de-escalation training and implicit bias. When he saw tears well up in the eyes of a grieving mother as the officer said, "I'm sorry," at a packed church, he understood that legal victories were more than money. They were about recognition and accountability. Meanwhile, he began co-authoring amicus briefs in cases before the Supreme Court, working with national civil rights luminaries like Sherilyn Ifill and Neil Katyal. He contributed to briefs opposing the travel ban that targeted Muslim-majority countries, supporting LGBTQ rights in the Obergefell versus Hodges litigation, and challenging the gutting of Section 5 of the Voting Rights Act in Shelby County versus Holder. Each brief required him to synthesize empirical research, voting patterns, demographics, policing data, and present a compelling constitutional argument. When he stood outside the court after decisions were handed down, crowds chanting, "Love is love" in one and justice denied in another, he felt the weight of history pressing on his shoulders, the sense that each loss was not only a defeat for one cause but a barometer of national sentiment. By 2019, he transitioned to a position as senior counsel at the American Civil Liberties Union in Washington, D.C. working directly on litigation strategies to challenge racial profiling nationwide. He led the legal team supporting the plaintiffs in a case against the Phoenix Police Department, which had deployed military-grade equipment in predominantly black neighborhoods and used geofencing to make arrests. He argued that such tactics violated the Fourth Amendment's protections against unreasonable searches and seizures. After a long trial, the district court ruled in favor of the plaintiffs, ordering Phoenix to revise its policies and enhance civilian oversight. The decision sent shockwaves through law enforcement agencies across the country. That summer, as protests erupted in response to the death of George Floyd, he joined the nationwide Legal Defense Coalition for Arrested Demonstrators, coordinating rapid response teams in Minneapolis, Atlanta, New York, and Los Angeles. He spent weeks on the ground in Minneapolis, compiling affidavits, interviewing witnesses, and filing motions to secure release for peaceful protesters held on exorbitant bond amounts. He also testified before the House Judiciary Committee on the need for federal reforms to limit qualified immunity for officers who used excessive force. When he spoke on the dais, his voice cracked with urgency. "We stand at a crossroads. The laws that shield bad actors in blue must be dismantled if we are to honor the promise of the Equal Protection Clause." Those words were quoted in newspapers nationwide and circulated on social media, cementing his reputation as a leading voice for racial justice. In late 2020, after several years of building an impressive body of appellate experience, he was approached by longtime mentors who urged him to consider joining the appellate staff at the Department of Justice's Civil Rights Division. There, under the Biden administration's renewed commitment to civil rights, he was tapped to lead the appellate section on criminal enforcement. Accepting the position meant leaving the ACLU, but he recognized the opportunity to influence DOJ policy directly, to oversee appeals in major police misconduct cases, and to ensure the federal government brought its full weight to bear on systemic injustices. Living in a modest row house in Capitol Hill, he spent early mornings drafting briefs on behalf of convicted men who had been denied effective counsel or racially victimized by jury selection. He met with attorneys from various U.S. attorneys' offices to discuss strategies for prosecuting civil rights violations and siege crimes, and he coordinated with state attorneys general in multi-jurisdictional matters. By 2022, he had argued several cases in the Fourth and D.C. circuits, earning plaudits for his eloquent advocacy before judges who remarked on his mastery of both law and lived experience. One memorable argument involved a petition to review a district court's decision that blocked federal consent decrees requiring police departments in Mississippi to reform demographically skewed stop and frisk practices. Isaac argued that the harm inflicted on black communities was not merely demeaning, lurking indignities, as he called them, but directly implicated the constitutional liberties guaranteed by the Fourth and 14th Amendments. The judges asked pointed questions about how to balance law enforcement needs with civil liberties, and he responded by citing empirical studies showing that targeted disruption of racialized policing yielded meaningful drops in crime rates without vilifying communities. Although the appellate court remanded the case for further fact-finding, the exchange demonstrated to the nation's legal community that he was a formidable presence in the appellate bar. In 2023, rumors began circulating that the Supreme Court's Office of the Solicitor General was seeking counsel to represent the federal government in an upcoming case, Brown v. United States Department of Justice, a challenge to a DOJ policy permitting federal agents to use facial recognition technology without warrant in certain circumstances. Civil rights organizations argued that the policy disproportionately targeted black individuals, as they were more likely to be misidentified by the algorithms. When Justice Elena Chen retired from her role overseeing racial justice litigation, her successor, Deputy Solicitor General Monica Reyes, invited Isaac to join her in Washington as a principal deputy to craft the government's position. She explained, "We need voices that understand both the law and the communities it affects. Your background makes you uniquely qualified to ensure we pursue justice rather than expediency." He recognized the gravity of the opportunity to shape the federal government's defense of critical civil rights issues before the highest court. In early 2024, Brown v. DOJ was calendared for argument before the Supreme Court. Isaac prepared for 2 months, compiling briefs that wove together legal precedent, Carpenter v. United States, Riley v. California, and more, with social science research on algorithmic bias. He collaborated with expert witnesses from MIT and Howard University who testified to the disproportionate false positive rates for black faces in facial recognition databases. He also arranged meetings with community leaders from across the country who recounted stories of wrongful detentions due to biometric errors, incidents that had left families devastated. When he presented his final draft of the government's brief to Deputy Solicitor General Reyes, she nodded gravely. This is the strongest we can do. It centers racial equity without undermining the rule of law. On the morning of March 15, 2024, Isaac arrived at the Supreme Court in his customary dark suit and light blue tie. The winter mist gave way to a clear, cool day. Crowds of law students, reporters, activists, and tourists converged on the marble steps. Getting through security, he felt a familiar hush fall over him, a clarity born of long preparation. Under the ornate pitch pine ceiling of the courtroom, he sat alongside Deputy Solicitor General Reyes, reviewing notes on the bench. When his turn came, he rose with measured confidence. He addressed Chief Justice Harriet Sullivan and the 8 Associate Justices. Mr. Chief Justice, and may it please the Court, the question before us is whether the Department of Justice's facial recognition policy, as currently implemented, violates the Fourth Amendment because it permits warrantless searches that disproportionately impact Black Americans, thereby entrenching racial injustice in our criminal justice system. His voice was steady, resonating through the hushed chamber. For the next 40 minutes, he guided the justices through the precedent and statistics, explaining how in United States versus Jones, the court recognized that technological invasions of privacy require heightened scrutiny. How in Carpenter, the court held that prolonged GPS monitoring constituted a search, and how in Riley, Chief Justice Roberts wrote that technology used in new ways can implicate privacy in ways the framers could not have imagined. He then tied those principles to algorithmic bias. We submit that the same logic extends to facial recognition, a technology that, despite its promise for public safety, has been shown to misidentify Black individuals at alarming rates, leading to wrongful detentions, community mistrust, and further marginalization. This policy, unbounded by warrants, inflicts unique harms on Black communities by subjecting them to surveillance that is both error-prone and unchecked. One justice, a conservative who had previously expressed skepticism about algorithmic bias, asked Isaac, "Can you provide examples where the use of facial recognition resulted in demonstrable constitutional violations? How do we weigh the potential law enforcement benefits against the risk of error?" Isaac nodded and replied, "Yes, Your Honor. In Detroit, a Black man named Robert Williams was briefly detained at gunpoint, discharged from his job as a high school teacher, after a 2019 Walmart jury-faced camera mistakenly matched his face to a suspected shoplifter. In New Orleans, a young Black woman was misidentified as a violent parolee and held in custody for 12 hours before DNA and fingerprints confirmed her innocence. These are not isolated incidents. They reflect systemic failures. While the government contends that facial recognition enhances public safety, we demonstrate in our brief that any marginal benefit is outweighed by the constitutional costs, the deprivation of liberty, the stigma inflicted, and the erosion of trust between law-abiding Black citizens and law enforcement. The justice nodded thoughtfully as Isaac elaborated on alternative, less intrusive means. Body cameras, eyewitness identification with safeguards, heightened training for investigators. All are proven methods that respect privacy and preserve dignity without inflicting disproportionate harm. A liberal justice then probed, "If the court strikes down this policy, what guidance would you offer for drafting a constitutionally permissible approach?" Isaac answered, "We propose that any use of facial recognition must be tethered to individualized suspicion, evaluated by probable cause, and subject to robust oversight. Specifically, we recommend that the DOJ require a warrant before deploying facial recognition in criminal investigations, with exceptions narrow enough to address exigent circumstances, but not so broad as to allow warrantless searches in routine situations. Additionally, we urge the establishment of an independent review board to audit facial recognition use, ensure data security, and monitor civil rights impacts." The justice nodded, scribbling notes as the next attorney for the petitioner rose to respond. When oral arguments concluded, Isaac walked out of the courtroom into the bright midday sun. Reporters clustered on the steps, microphones thrust forward. He paused only to say, "My job here is to ensure that the law protects all Americans equally, and I have faith in this court's dedication to constitutional principles. Later, standing on the Capitol grounds, he sent a quick text to his parents. Argued at SCOTUS today, feeling hopeful. His mother responded with a string of emojis, and his father replied, Son, you carry our prayers. We're proud. Over the next 2 weeks, press coverage on Brown versus DOJ intensified. Activists praised Isaac's arguments. Tech companies lobbied for outcome favoring law enforcement. Civic organizations held webinars to educate the public on facial recognition's implications. And churches in Jackson organized live streams of Supreme Court updates. Isaac continued to work behind the scenes, drafting additional memos, advising the Solicitor General on possible remand language, and ensuring that department counsel across the country prepared for either outcome. On April 23, 2024, the Supreme Court issued its decision. In a tight 5-4 ruling, the court held that the DOJ's facial recognition policy, as currently structured, violated the Fourth Amendment's guarantees. The majority opinion, penned by Chief Justice Sullivan, cited Carpenter and Riley extensively. Technology, when misapplied, can create modern forms of surveillance antithetical to constitutional protections. The opinion specifically noted Isaac's arguments and empirical data on racial misidentifications, acknowledging that the disproportionate harm experienced by Black Americans under this policy compels the court to demand stricter safeguards. A dissent authored by Justice Grayson decried the majority's short-sighted view on national security, but the majority remained firm. Law enforcement must respect the liberties of all citizens and cannot trample upon them in pursuit of convenience. When Isaac learned of the decision in his West Wing office, he closed his eyes, repeating a silent prayer. He called his parents immediately. His mother's voice trembled as she said, "We knew you would do it." His father, voice thick, murmured, "You made history today, son." In the days that followed, he was inundated with messages of gratitude. Former clients whose cases he had argued in, lower courts, colleagues he had mentored, students he had once tutored in Selma, all expressing how meaningful it was to see a Black lawyer from humble origins stand before the nation's highest court and secure a victory for justice. As summer came, he took a brief leave to return to Selma. He stood once more on the bank of the Alabama River near the Edmund Pettus Bridge, where a small ceremony had been organized to celebrate the Supreme Court decision. Local pastors prayed, high school choir students sang "We Shall Overcome," and community elders recounted how far the movement had come since 1965. When it came time to speak, Isaac stepped to the podium and said, "This victory is not mine alone. It belongs to every person who has fought to be seen as fully human under the law. It belongs to the elders who marched across this bridge, to the mothers who taught their children to read the Bill of Rights, and to those who continue to breathe and hope for a better tomorrow." The crowd erupted in applause, and he felt tears prickle his eyes. By September 2024, he returned to Washington to his position in the Solicitor General's office. He spent the fall drafting amicus briefs for other cases, voting rights disputes, prison reform litigations, and school discipline challenges, knowing that the fight for equality required constant vigilance. But he also felt a profound sense of resolve rooted in his journey, a journey that began in a small Alabama town, progressed through brush arrests and expulsion from peaceful protests, and culminated in arguing and winning a landmark Supreme Court case. Each step had been guided by family wisdom and tempered by hardship. As he looked ahead, he remained certain that if a lawyer's duty was to speak truth to power, then he had found his calling. In the final analysis, what had begun as a single act of protest against racial injustice evolved into a career devoted to ensuring that the Constitution protected all citizens, especially those historically marginalized. Isaac understood that representative justice at the Supreme Court level was not an endpoint, but a beacon, illuminating pathways for countless others. Children who believed in fairness, students who saw in the law a way to challenge discrimination, activists who demanded more than mere promises. And whenever he felt the weight of that responsibility, he remembered his grandmother's sewing machine humming in the background, the hush of that bridge on a summer afternoon, and his first arrest outside a local rally, reminders that he had always belonged in the struggle for justice, and that the law, at its best, was an instrument of hope rather than a shield for oppression.